Thank you all for tuning in today. We're going to have a good time. I wore my best tie and everything. So, I mean, we are just ready to rock and roll in all sorts of fun ways on the forums today. Let me share my screen with you guys. We recently revamped the NC Realtors website, and it was something that I was very much looking forward to. I think the NCR staff has done a great job with it. Like any other website, you first roll it out, it's going to have some hiccups, but the upgrades to this website are very significant compared to the old website. So I want to take a minute before I get into anything else to show you some of how this new website works. Interestingly, the new website is dynamic. And what that means is that it'll look different depending on the size screen you got. So if you're looking at it on your phone, it'll be a little bit different from your computer. Today, we'll be looking at it on a 13-inch laptop. So that'll be a little bit different than, say, a big screen. So just so you know, if your screen doesn't look exactly like mine, that's totally cool. It means it's just optimized for your particular screen to make sure that it operates the best possible. Okay. So if you go to ncrealtors.org, what you have here at the top is several different options of things you can click on. Okay, Convention Expo, Forms Library. We're going to go to the Risk Management Library. Risk management is something we will talk more about, I'm sure, in other sessions, because there's a whole new risk management library with other articles that aren't even Q&As. They go even more in depth, and they are to help you with exactly what it sounds like, which is risk management. Right now there's forms topics, but there may be other topics coming in the future. In any event, so we go to the risk management library, and this is not what I want. This is not what I want. Hold on. I'm gonna try again here. Click on risk management tools. Here we go. Because this is where we need to go. The Q&As is where we put the summary of forms changes. And so if you guys do nothing else today, if you get bored of my Midwestern nasally voice in about 5 minutes, then what you can do is actually go to the thing that I'm about to show you, and you can see all the forms changes for yourself that we will be covering today. You will not get the interesting commentary. However, the form does a pretty good job. So the Q&As are listed a little bit different right now on the website, okay? And you can filter them by topic. So that's this right here. On a bigger screen, there'll actually be something on the left side where you can do little check boxes. So that's pretty cool. You can sort them right now. They're just sorted by date. You can see right here, published. Right here is the date on the side, and you can see that they go in order. Or you can publish them by name, either way. So those are just some things you can do to navigate the Q&As. It's a little bit different than how it used to be before. What I usually do is use this search bar at the top. This search bar, if you use the search bar on the old website, it was not good. This one is very good. It will find things for you much more efficiently and better than the old one. So if you're looking for a particular thing, then you can search it up here. You look down here. You can see as I'm scrolling, it's auto populating, and we're not going to have to go down too far because we just released all the summaries for commercial, residential, and property management. We are going to go through this one here today, and I already have this tab up, so I'm not going to click on it. When you click on it, it takes you to here. This is a Q&A because it's in that section of the website. However, instead of just a question and answer format as the Q&As usually are, what this is each form you go through and it says the changes. These are summaries here that I've written of the changes. And these blue things here are what are called hyperlinks. You click on the hyperlink, it's going to take you to the form. And this is how I sort of prefer to go through forms changes every year. And that is to actually click on the actual form and let's look at the actual black and white of what's changed. Because in the links, you'll see yellow highlights of all the changes, strike throughs to show it's been taken out, and then there'll be highlighted language to see what's been replaced. So you can now go do your Wordle. Or personally, I like the waffle. If you're not playing the waffle every day, that's a fun game. It's just like Wordle, except it's a waffle of Wordles, if you will. Anyway, that's neither here nor there. Let's get into forms changes in 2T. We're going to start with 2T. We're probably going to spend the bulk of today in 2T. I'm going to try and keep us under an hour with Q&As. if we do 45 minutes, I'll be very proud of myself. I'll pat myself on the back for that. But there's a lot of things to cover and a lot of important things to talk about with respect to the changes this year. So on the first page here, this is a change to help you with a couple different things. Number one, the manufactured housing checkboxes that used to be here, they're right here. Okay, they haven't really gone anywhere. They're just right here. But we've added something here to help give you some checkboxes for whether the property is going to include an off-site, and there's a key term there, off-site and or separate. So it can be off-site, separate, septic lot, boat slip, garage, parking space, or storage unit. Why has this been added? It started with a discussion about boat slips primarily, but then it really got into a discussion about how all these things in this list can be separate. They're ancillary to the real property, or in some cases with a septic lot, critical to the real property. But the biggest thing is the closing lawyers. Just so you know, there's two different committees that work on this particular form. Some of our forms are joint forms. What that means is that there's a forms committee, which is primarily made of realtors. I'm a lawyer on there. I'm a non-voting member. There is one lawyer from the Real Estate Commission who is a voting member on the forms committee. Everyone else is realtors. Okay, so that's one committee. The other committee is the Joint Forms Task Force, which is some members of realtors and also members of the NC Bar Association Real Property Committee, Real Property Section. So you have like these two groups of people that will discuss any forms, and any forms change in 2T and any other joint form has to go through both of those bodies in order to be approved. So this particular change came from closing attorneys on joint forms who it just was happening way too often where these issues would come up late in the transaction. Well, late in the transaction is a very bad time to find out about a boat slip, garage, parking space, or storage unit or septic lot that's off-site. Okay, so it's at the top of right here. And also this note, if you have any of these things, all it says is attach the additional provisions addendum, and it will guide you through that more. And instead of actually going through the rest of 2T, let's go ahead and go to the additional provisions addendum now, and then we'll come back to 2T. Because there's no point in waiting to do that. So over here, nope. Where is the additional provisions addendum? Did I not bring that up? All right, well, I'm going to go back here and I'm going to do it. Hold on a minute. I might have pulled it up somewhere. I just didn't remember it. Okay, so in the additional provisions addendum, we'll talk about these rental property changes a little bit later. There's more check boxes in Form 2T for that, but we won't necessarily have to come back here. I'll just mention it again. There's some extra requirements here, nothing too critical. Things are already happening in transactions, but just to make sure that it's clear between the parties, especially what the seller needs to do to provide information to the buyer and also to deliver an assignment of the lease at closing. So that's in there. Also access right here. Scroll down, and here we are. We have a new paragraph 7, the additional provisions addendum, to talk about off-site and or separate septic lot, boat slip, garage, parking space, storage unit, things of that nature. And here you can check whether it's deeded, leased, seller owned, or HOA owned. You're going to check all that apply, because there are going to be situations where it's both seller owned and deeded, and there's going to be it'll be HOA owned and leased or part of a deed, things like that. If none of the boxes apply, that's okay. Just describe it the best you can in these lines. That's what these lines are for. And then finally, if you've got like an unagreeable seller who maybe needs to execute some extra documents to make sure that the transfer happens for this particular offsite thing, right here, this language here obligates the seller to do that at their expense. So just understand, point out that language to them if you have somebody who's, being difficult in that arena. Back to 2T. Scrolling down further, technical change right here with 5 days being moved to harmonize better with the other parts of the contract. Some language added here about dishonored funds. Really, that's just to make clear that if you get a bad check you get all the remedies at law. You're not limited to just, attorney's fees and court costs, things of that nature. There wasn't necessarily a problem with that we had to address, but I was afraid that a court may interpret it that way. And there's a lot of remedies for a bad check. If you get a client that gets a bad check, you want to recommend that they go seek legal counsel, because there's a lot of other ways that they can be made whole if they get something like it, because it honestly is very inconvenient. This note was moved, so I'm not going to cover that. That's highlighted just because it was moved. Here, paragraph E was simplified just to say, the earnest money is going to be dispersed as required in the contract, instead of this 1 and 2 down here, which was not quite accurate. Scrolling on down, this is actually in the contract twice, this yellow language. This yellow language also appears at the end of the contract. However, even though it was at the end of the contract, right before the signature lines, it was frequently, it's a very common question we get here on the hotline, which, sorry, I didn't introduce myself at the beginning, so I'll go ahead and do that now. My name is John Wait. I'm a partner at Martin and Gifford in Winston-Salem. We're a law firm there. We are general counsel to NC Realtors. And one of the things that I do is help the committees write the forms that are explained. And, my law firm handles other various things for the state association. One of the things that we do is man the legal hotline. If you're not familiar with the hotline, it's a free member service. You can email the hotline at legalhotline@ncrealtors.org. Or there's also a phone number, which is the main office in Greensboro. All that information is on the website if you want to contact the hotline. So back to my comment about this particular change, is that the parties, it's frequently a question, if the money's not paid, is there a contract? Yes. The answer is always yes. The effectiveness of the contract has nothing to do with whether the money's been paid or not. Now, if the money's not paid on time, then the seller has the one banking day solution up here, and you can use form 355 to make that demand. In case you weren't aware that there's a form that does that, there is one. So the seller can demand the money since it's not paid on time. But that has nothing to do with whether you have an effective contract or not. If whoever signs it last, and that person communicates to the other side, it could be verbal, it could be a text message, it could be an email. Once you communicate that your client is signed and your client is the last one to sign, the contract is effective regardless of where the money is at that point. So that disclaimer is here, and it is also at the end of the contract still. And actually, I think it's highlighted again this year because it was actually bolded. All right, scrolling on down. Exercise equipment is added here as a bullet. It's just pretty common. It's just more common, especially since COVID, for there to be exercise equipment that's not, it's not personal property. It is actually attached to the home in a way that a fixture would be. The default is that those things are going to be attached. And if the seller doesn't want to convey them, then he better exclude them. Interestingly, if the seller does exclude them, there's been a slight change here. And that is that anything that the seller does with respect to damage caused by removal of any of the items, so say they exclude some exercise equipment, they remove it, they have to repair that in a good and workmanlike manner. That's not an exact science of what that is. There's no exact definition. However, we all know what that looks like. And generally, you're going to look at it through the eyes of a reasonable person. What would a reasonable person believe to be good and workmanlike manner, right? So that's been added here as a requirement if the seller does remove any sort of fixture equipment in the property before the buyer comes in. And there's also a sentence here that the seller will notify the buyer and provide the buyer with documentation if there is any. There's also a note here that's been added. It's a new note where if the buyer is very particular how they want something fixed, then they better do the additional provisions addendum and have those specifications outlined very clearly. Moving on down. There's something added to this paragraph here was changed to accommodate the buyer. Hold on just a second here. Gotcha. Sorry, I had to look at my chat box for just a moment there. And now it's in my way and I can't move it. Hold on. There we go. All right. This paragraph here, this is a reminder for the buyer to check governmental compliance. And we're going to get to paragraph 8H. Probably many of you have questions about 8H. So we will, we'll get to that more in a minute. This has been added though to just alert the buyer that as part of their due diligence process, they need to be looking at the property's compliance with government regulations. Okay. Scrolling on down. This warning box has been added here under lead-based paint because it was already the law, but it was something that maybe not everyone was aware of, and we didn't want this to be a landmine that agents would potentially stand on. This will give protection to you to make sure that, especially the seller, knows that if they don't give the lead-based paint addendum and the disclosures therein, along with the brochure, then the buyer could potentially terminate the contract all the way up to closing and get all their money back. And that's not something that we made up. That's not something that hasn't been the law for a long time. It has been. It's just something there seem to be more complaints about sellers not wanting to fill that form out. This warning is here just to give you some cover to say, all right, fine. You don't want to fill it out. That's up to you. But here's the risks if you don't do that. So it's right here for you to point out to your clients if you have a seller who wants to make an issue about the lead-based paint addendum in the brochure. As I mentioned earlier, the additional provisions addendum has a bunch of changes with the landlord / seller obligations. This here is a checkbox to show whether the property is subject to a lease. And if it is, then make sure you attach the additional provisions addendum. Now, granted, if you don't include the additional provisions addendum, if somebody forgets or whatever, that is not the end of the world. In fact, check this box. You can please use this. This is especially going to help the closing attorney in your transaction. But at the same time, even if you don't check these boxes, it's not the end of the world, because North Carolina law provides that if you buy property and there's a tenant in that property, you are taking title subject to the tenant's possessory interest, whatever that is. If it's verbal lease, if it's written, if it's, grandma let the grandson move in for an indeterminable amount of time, that's what you're buying. So just understand that and understand what it is. This is to help hopefully give clarity to your clients and to the closing attorney about what exactly the status of a tenant is in the property. But if you do have an issue in that arena, it's something that probably very likely can be worked out. So, don't freak out about it if you forget about it. You have my permission not to freak out. All right. Paragraph 8G. This paragraph used to be, not used to be, it has been in the past, interpreted in different ways if a party's trying to get out of a transaction. I was on the hotline this morning and actually had a question about this morning, where a buyer's lawyer is creating a lot of ruckus and noise about a setback issue and trying to sort of shoehorn that setback issue into the seller's breach of this paragraph 8G. And interestingly, some of these arguments were more compelling by others for buyers. But what this tweaking of the language is meant to do, it really focuses on this word materially right here. It has to be a material, effect of the actual title. Now, that language wasn't in there before. It's to hopefully cut down on these buyer claims of these like ticky-tack things that they're trying to make into mountains in order to get out of the contract, maybe after the due diligence period is expired. Will it actually accomplish that? We will see. I think it's a good change regardless of the actual effect. But just so you're aware, that is the standard going forward. And I think you could argue as a standard in the past. But it's got to be significant. Material doesn't mean insignificant. It means it's got to be significant. It's got to affect someone's decision-making ability. I actually wrote a Q&A 2 weeks ago about the next paragraph we're going to cover, 8H. And in that Q&A, I go through, and list the actual definition of material. So if you want some more context than that, you can read my Q&A for a couple of weeks ago. My law partner wrote a Q&A last week about the changes in the termination forms. We're going to cover those in a few minutes. All those are on the website in the Q&A section that we were just in, finding this summary right here. Paragraph 8H, I want to take a minute and just talk about why this was added, what the problem was. When the market began to heat up over the last couple of years, obviously everyone knows the amount of the due diligence fees increased. Generally speaking, most markets across the state, due diligence fees suddenly started getting much higher. And from what I can gather, they're still pretty high. So in most markets anyway, some markets I think have calmed down a little bit. Well, what that did is it put the buyer in some very unfair situations if there was an issue of governmental compliance that was discovered. Okay, let's say, for example, and this will probably be the most common thing / example that will be covered by this new paragraph, and that is permitting. So let's say the seller owns a property. He's been there a few years, and he decides to enclose the what was like a screen porch, but he encloses it, puts in maybe a mini split or something like that, and gets, so now it feels like finished space, but there's no permits or anything pulled for this thing. Okay, it's just unpermitted square footage that sort of operates as if it's finished. Okay, well, interestingly, depending on how significant, a change to the property like that is, you are talking about serious tax issues, because the tax department can go back a certain number of years and reassess your property for the increase in value. You're talking about potential zoning issues. You're talking about potential permitting issues, and the permit office not permitting this particular thing. Or in order to get a permit, in some instances, depending on the kind of change that was made, you're talking about ripping out all the drywall to look at plumbing and HVAC and electrical compliance and things like that. And some of these issues of just trying to get the permitting in line could be tens of thousands of dollars just to make sure that everybody gets access or fixes things that are wrong or whatever. These can be very significant things, certainly things that you could say are material that would affect a buyer's decision on whether to buy or sell the property, right? And the reason I'm harping on that again is because this 8H has several mechanisms built in. In any event, under the old form, the buyer got into this situation, discovered this oftentimes after the due diligence period had expired, and then was put in a position of deciding, well, do I accept all these permitting issues and close, or do I terminate and get my earnest money back, try to get my due diligence fee back? There wasn't an obligation of the seller to actually have the property in governmental compliance under the old contract. And it's not a title issue. More times than not, vast majority of the time, these were never title issues. The seller could deliver title as marketable and insurable, but the property just had this huge, issue with permitting that the buyer may or may not have wanted to deal with. And finally, and this is perhaps the biggest part, is that the seller only has a duty to discover latent material defects that are not within the discovery of the buyer by reasonable diligence. Well, that's a much different standard than material facts, right? The listing agent has to disclose material facts. Seller has a much, much, much higher bar for disclosure. And in the case I'm talking about, if you go back to my example, the buyer found the permitting issue by reasonable diligence, or in most cases would. So the buyer is stuck in this position where they have to basically take this thing that they otherwise wouldn't have wanted at all, or risk losing a substantial amount of money. So that was the issue. That was the problem. It was happening, pretty regularly across all markets. So this paragraph was discussed by both joint forums and the forums committee to try and address this problem. There's been a lot of feedback about it. I expect both committees to take it up again, tweak the language, do what they need to on it to try and make it work better. I can anticipate probably some of the questions that will come out of this, but let's go through how this paragraph actually works. So number one, this paragraph is a condition of the contract. And what that means is it operates much like the condition of property at closing. If it's out of compliance, if a property is out of compliance, then this paragraph is going to specify the buyer remedies. Okay, it's not going to be a breach of contract. It just means that the seller is making a representation that the property is going to be conveyed free of any material violation of law, ordinance, permit, government regulation. That's the first line. Okay. So let's break that down a little bit. Number one, it's a condition. Number two, there's two safeguards in here before this is going to kick in. Number one is material. So if it's a small violation, no, not going to happen. If it's, and this discussion actually occurred in the forms committee, they actually, they talked extensively about this. But let's say that you live in a jurisdiction where, technically speaking, you would need a permit to do a ceiling fan. You need an electrical permit to add that outlet. Is that going to be something that's going to trigger this paragraph? No, that's not material. At least I don't think a reasonable person would think so. So understand that's the first threshold that anybody's going to have to cross in order for this paragraph to apply. It's got to be a material violation. All right. So even assuming it's a material violation, what's the second safeguard? Second safeguard is unless seller has specifically disclosed prior to the effective date. So what that means is, even if you've got a material violation, even if the property is, you've got this screen and porch, okay, it is definitely not permitted, it's material, well, the seller can just disclose it. This paragraph is not going to apply at all, because if the seller discloses it, they're only making a representation that the property is free and clear of material violations, except for those that they have disclosed. So understand those are two big hurdles that any buyer is going to have to get over before they get to this last part here, which is this. So let's say, buyer goes under contract. So the buyer discovers this screen and porch that's been, turned into what looks like finished space, hasn't been permitted. Seller doesn't disclose it. What now? So if a violation is discovered after the effective date, but prior to closing, and that's important too, because this paragraph, I think, by its own terms, is not going to survive closing. Okay, this condition is of the contract itself, and so if something's found post closing, paragraph 4H, where you accepted the property as is, it's going to kick in, and that's going to be a difficult hurdle for the buyer to get over. In any event, so if a violation is discovered, not disclosed, then there's an option. The first option is that the seller can cure the violation. Okay, so that's number one. And if they cure the violation, then that's going to be it. That'll be the end of the story. However, if the seller doesn't cure the violation, then the buyer can choose to proceed to closing if they want, or they could terminate and get their earnest money and due diligence feedback. And that's it. Not inspection costs, not lawyer fees, not any of the other things that you'll see in paragraph 23 for breach. Okay, so that's how this works. Hopefully that gives you some context about this paragraph and why it was added. I'm sure there'll be some questions about it that I'll try and get into. One question that has been coming up, this is like my sixth or seventh forms presentation, so I can anticipate some of the questions. One question that has been coming up pretty frequently about this paragraph is, what if it's an older home, it was in compliance at the time and now it's not in compliance now? I don't think this paragraph was designed or intended to capture those kinds of situations. It is something that if the house gets a CO, and that CO is just good, generally speaking. I don't want to overgeneralize too much. All I can tell you is not the intent of the paragraph to catch those situations. And there may be some adjustment to the language to make that a little bit more clear. Let's see, I'm trying to think if there's any other common questions with this paragraph, but not that I can think of off the top of my head. And anyway, we'll probably get into that. I'm going to keep moving just because I want to give time for the Q&A, and we still have several forms to go over. All right, so that's paragraph 8H. This is paragraph 8I. It used to be 8H, now it's 8I. And I have some bad news for you. You need to stop filling out the blank on this paragraph. I know agents are not going to like this, but here's the problem. You guys aren't filling this out correctly. You have not been filling it out correctly. And it's round about 75% of the time from the survey of closing attorneys that I've talked to, that this is not filled out correctly, and the closing attorney has to do their own fact-finding search to see who the deed needs to be made out to anyway. That doesn't even include situations where, say it's a mom and daughter buying the property and, things of that nature. It's just something where that's what they have to do as part of the process already. And then in some rare instances, you'll have a seller who doesn't want to change, say the buyer does want to add somebody to qualify for a mortgage. Say they want to add their mom, it's a daughter's buying the property, wants to bring mom in to help with the co-signing the mortgage so that they can buy the property. And then, of course, the lender is going to require that both names go on the deed, right? Well, then you would, under the old form, if you only had the daughter's name in this paragraph, then the seller would claim that that's an amendment to the contract and try and hold it up. And anyway, cantankerous sellers, I don't think there's a very good argument for that, but they would do it anyway. In any event, what this does is make it so that you have the buyer, right? The buyer is right on the top page. You fill that in. The deed can be made out to the buyer. Even if it's multiple people, the definition includes all the people on that line on the first page of the contract. A corporation, limited liability company, or other business entity of which the buyer is the sole owner or shareholder. So, some sort of LLC or something like that, that the buyer. Now, this can be done without you writing anything. You don't need to write anything, okay? The deed could automatically be made to those two things just by virtue of you filling out the contract. Number 3, a trust for which the buyer is a beneficiary for any relative of the buyer. And this has already been corrected. I don't know how we missed this one. It's number 5. It shouldn't be E. It's very embarrassing. But anyway, sorry, we're not perfect over here. We just do the best we can. In any event, number 5 is other. And other is going to include situations where, people are not related, say it's a significant other situation, but they're not married. They're not related. Hopefully it's a significant other situation. Then you're going to insert names, and insert names only, not to be determined, not NA, not any of those things you used to put in there. Okay. That is the only time you're going to fill out that blank. Other than that, you're just going to let the closing attorney do their thing. They are going to use this pre-printed language to make sure the deed gets made out to the right people. Okay. All right. Moving on down. I'm going to skip that one. I'm going to skip that one too. And that one too. All right. And as I said, this is bolded again at the end. Money is not relevant to whether the contract is effective or not. All right. That is Form 2T. Let's go ahead and move on here. Sorry. So there's 2 new forms that I helped Forms Committee draft this year. One, they're new guidelines. It's guidelines for the buyer possession and seller possession forms. And I really tried to write these in a way where I wasn't regurgitating a lot of the same information from the form to the guidelines. The guidelines are really to provide clarity. Number 1, like right here, it's a pretty common question with these forms. Well, how do I know if I need, depending on how many days the buyer seller is going to be in there, that I don't need an actual lease instead of using this form instead. Number 1 talks about that. Also down here, there's talk about the eviction process and sort of the basic nuts and bolts of that. These are meant to be something that are helpful to you and your client. So just know these new guidelines are out there. And if you have a buyer or seller possession, then it's probably a good idea to just hand those to your clients so that they know what's going on. For those of you that do vacation rentals, this vacation rental addendum it's an addendum to Form 2T. There is a note here about VRBO and Airbnb that they can potentially be subject to the Vacation Rental Act. That's just an added note there. The important change is down here, however, and I want to take a minute to cover this because I think it's pretty important for those of you that do vacation rental sales. The problem that this change is meant to address is that in many vacation rental transactions, the buyer and seller would sort of have a side agreement that the buyer would take on the seller's property management company. And the thought being that if the buyer does that, the seller gets to avoid the early termination fees that they're going to have to incur with the property manager if they terminate early by selling the property. Okay. Well, as you might imagine, this was not a paper. It was all kind of handshake, and buyers would get close to closing and then be like, actually, I found a better deal with this other property manager, so I'm just going to do that. Well, now the seller's stuck. And the seller, in many of these cases, wouldn't have taken the contract if the buyer was going to do that. It was a significant and material thing that they based their decision to go into contract, in the first place. So what this does is give a mechanism to not necessarily put this agreement in writing, but just to provide a remedy if the buyer does back out. And what it says is that, it identifies the current rental manager, and then, the buyer can go with whoever they want. But the agreement is that if the buyer doesn't hire the seller's property manager, then the seller's gonna get a credit of blank at closings to be negotiated between the parties. That number can be zero. It can, and zero would indicate, no, I'm picking whoever I want. You're on your own with respect to your property manager. Maybe it's going to be half of whatever the seller's expected damages are going to be for terminating early. In any event, if you're the listing agent, you want this number in the blank to be as close as possible to whatever the property manager is going to be owed for the breach. And that's going to require some numbers and some calculations and probably an uncomfortable phone call, but something that you're probably going to have to do, or maybe more importantly, your client has to do, depending on how you want to do it. So anyway, just understand that's in there. If you do vacation rental sales, that's in there to try and help the parties navigate that territory. On the listing agreement, let me scroll down here. Again, exercise equipment. And down. Page 7. Page 7, we've included a couple of new disclosures. Number one, if there's any potential or pending dispute, violation, or litigation that involves the seller, HOA, or the property, there's a material fact that you've got to disclose anyway. And understand this, the reason we're putting a little bit more onus on the seller to make a little bit more disclosure. Number one, to disclose things to the listing agent might not already know. But also, if you go back to paragraph 8H, Form 2T, the seller making the affirmation about government regulation. Another part of this that I don't want to run past for those changes is that it's a significant risk management issue for agents. That being, on the seller side, as I explained, the seller doesn't have the same duty as a listing agent for disclosure. And then you would have buyers, pointing the finger at the listing agent about something the listing agent didn't even know. So we're trying to improve that communication between the listing agent and seller for that reason. And then also trying to improve communication between the buyer and the seller to make sure agents, to make sure that those parties aren't turning around and pointing fingers at agents when things are not discovered that they think should be discovered, or things should be disclosed that they think should be disclosed, or vice versa. In any event, so that's what F is for here. G is FERPTA. That's just a discussion you want to have for your client due to how important that affidavit is at closing. So just make sure you talk to them about that. Those check boxes are to prompt that conversation. As we continue down in Form 101, we have 2 new paragraphs here, one for the offsite or separate septic lot, boat slip, etc., and one for governmental compliance. All right. And here, once again, we put it in twice, trying to look out for you guys. Lead-based paint warning for the seller. And that is it for Form 101. This is Form 320. It is a new form, which is why you're not going to see any yellow on it. There's not changes to it. It's brand new. And I'm pretty excited about this form, I'll be honest. I really have been wanting this for a long time. I think it's going to be a net overall benefit for you guys. I'm going to cover the mechanics of it just real briefly. It is exactly what it sounds like. It's an agreement for bill sale of personal property. So if all the furniture is going with a vacation rental addendum, vacation rental property, you're going to put that stuff in here. Even if it's just the refrigerator, I would strongly encourage you to put it in here. This is not an addendum to the contract. Lenders do not want to see this or know about it or care about it. Okay, we asked them. They said so. So Do not do it as an addendum to the contract. It is a completely separate agreement. But the interesting thing about it is this, these check boxes right here in the middle. You can see that this agreement is or is not contingent on the seller and buyer closing on an offer to purchase a contract. So if you got a vacation rental, chances are, if you're selling the furniture with one of these, personal property agreements, you're going to put the is box. You're going to check the is box. And the reason you're going to do that is because the seller doesn't want to get rid of all his furniture in most cases, unless it's going to go with the property. He's not going to sell it separately. So just make sure that you get those boxes correct. And if the seller doesn't care, if the seller wants to sell property, then that's fine. There's a little blank right here. You put in the money, not contingent. All right, then it's done between the parties. Some disclaimers here, mostly that the seller makes and that the buyer assumes responsibility for the purchase. And that's pretty much it. I tried real hard to make sure it stayed one page. It's supposed to be simple. If you have more things to sell than what'll fit in these lines, just do see attached and attach a page with all the personal property on it that you're selling. Okay. This is Form 350. I want to talk about some new check boxes on here. All right, we're going to make sure. Yep, 350. So notice, first of all, that this language here about unilateral right to terminate has been deleted, and that's intentional. Some of these check boxes are no longer a right, okay? And it's something that, the parties might do anyway, but it's not necessarily a right. We wanted to make sure that that was clear by making that adjustment. So first of all, the new check box that the buyer can terminate, if the property fails to satisfy government compliance, then they can terminate for that. They can check that checkbox. At the bottom is two new check boxes for the buyer to give notice of termination, even if most of the time they're going to check these, they don't have a right to do so. But what it will do is give clarity about the termination of the transaction. So no more of this sending Form 390 with the client's signature at the bottom and the listing agent going back and forth with you, trying to negotiate the terms of a termination when it's clear that the parties don't want to go forward in the transaction, et cetera, et cetera. It is a very, very, very common problem. And there's nobody that benefits with the termination of the contract being a gray area. There is, it's full of pitfalls for agents and quite frankly, for the parties too. So what these new check boxes are meant to do is to help you assist a buyer while also covering you, because both of these check boxes here strongly advise a buyer, and also the corresponding check boxes for a seller in those termination forms as well. We're only going to go over Form 350, which is the buyer termination, but just understand it's also in the seller termination forms. If your client wants to terminate and they're outside the due diligence period, or if they think that the seller has breached, then they can check one of these two boxes and send it on over. I just had a discussion this morning, and I want to be very, very clear on this. If the buyer sends notice of termination and says the seller is breached, that is, they can make that argument as much as they want to all day long. That is their right to make that argument. The seller doesn't have to agree to it. And if the parties can't agree on it and they really want to get serious about it, they can take each other to court. That's how it works. That's how it was before. That's how it is now. That's how it's always going to be. What this does is just give you a tool to make sure that the contract is at least terminated, so that the agents especially have clarity about, is there exposure to my client because of the contract remaining outstanding or not. That's what you need to know, because you don't want your client to be committed to another. If you're representing the buyer, you don't want them to go under contract with another property if there's still another contract outstanding. And especially with the seller, you don't want them to go under contract twice for the same property with two different buyers. Okay. So these new check boxes are hopefully to make termination more clear. It doesn't add any extra rights to anybody for termination at all. It is really just to put into a form what you guys were already putting in emails and sending to each other, which that was not a good thing to do. This will give a lot more clarity. All right. Moving on. This is the agency agreement renewal or amendment form. And there's one little change here. I just want to make sure that's clear, that Previous amendments, if you do an amendment to the agency agreement, the previous amendment is going to continue to be effective unless it's specifically changed in a new amendment agreement. Okay. I think there was some question about that previously, but now this language that's been added here makes it clear that, just so everybody knows, if you sign one of these and then there's an amendment to the agency agreement, that's going to continue to be effective, even if you sign some subsequent amendments that have nothing to do with the first amendment. Okay. And bring up the last one here. Last one is the referral agreement. And there's a grammatical error we got to fix in the second box here, and I understand that. So again, sorry about that. we will try to get it right. In any event, at the time that this was set up and printed, though, we hadn't done our final proofing, and so that's why it's in here. Anyway, there's a question or a problem or an issue with what happens if the person you're referring to the other side, closes on more than one property prior to the end date. And nobody knew because there's nothing in here that talks about that, but it was happening often enough that it was something that needed to be clarified. So the default is that if a prospect closes on more than one property, then you are going to get paid on both sides for both transactions. That's the default. If you want something else, there's an other box down here. You fill it out that way and specify exactly how it's going to be. But as far on the buy and the sell side, the intent of the language here is that, if there's more than one of those types of transactions during, before the end date here, then that is going to be effective. All right, I'm going to stop sharing my screen and I'm going to head over to the chat box here. And I see that we have some questions. And I'm going to get through as many of these as I can prior to 2 o'clock. If I don't get to all of them, just as I said, make sure you use the legal hotline. That's what we're here for, is to help answer questions on forms and anything else you might have going on with your transaction. So the first one, the question is, does number 7 of the additional provisions addendum include nitrification fields that might be a lot within the subdivision? Oof. I think you could make it work for that. I don't think that's specified directly in there. But I think you could add that in. And just so you know, under NC Realtors forms policy, if you want to strike through parts of the pre-printed language, then, if it's a contract between a buyer and seller can do that all day. It's great. Or if it's an agency agreement and you want to do that, then you can as the agent, because you're a party to that agreement. So if you want to strike things, that is okay. We get that question all the time. Or if you want to attach an addendum to either one of those things to change the terms, you can do that too. What you cannot do under the forms policy is get like a PDF editor and then get in there and start monkeying around with the pre-printed language so that you can't tell that that's what you've done. The standard forms are meant to be standard, and that means that the pre-printed language is standard. But if you're making an obvious change, like actually striking through language in the form, then that's perfectly fine. All right. Anyway, so all that said is that nitrification fields, that sounds like something you could probably add in there, but it's not specific right now. Second question is, if I'm interpreting the due diligence date correctly, due diligence money is due at the time of contract signing. That is correct. Let's see. Next question. Oftentimes a special warranty deed is issued instead. Should there be a box to check? That's a good question. I mean, I could bring that up with the committee and see how they feel about that. I'm not sure if that's a discussion they've had in the past or not. But I agree with you that that is a relatively common way to do it, especially if you're dealing with someone who's doing a wholesale type transaction where there's going to be a double closing. Those usually are special warranty deeds rather than general warranty. Yeah, that's something we can bring up and discuss in forms committee. regarding paragraph 8H. This is a question about the conflict between, well, a perceived conflict between Form 2T and the residential property disclosure statement. I guess I'll just talk kind of generally about those two. I think you have to understand that the residential property disclosure statement and the mineral oil gas rights disclosure, both of those forms, if you're required to fill them out, yes. If you don't, what is the maximum penalty? Well, usually in most cases, the buyer gets like a 3-day limited window where they could terminate the contract and get their due diligence feedback in addition to the earnest money deposit. And that's really it. Otherwise, if you don't fill it out, that's what it is. You're also allowed to fill it out and put no representation all the way down. You can do that even if you're a licensed broker. There's no exception in the law for no representation for brokers. Brokers can check no representation all the way through the residential property disclosure as well. But here's the catch. Catch is you are a licensed broker, and any of you who have bought and sold your own property know that you are still obligated to disclose material facts in your brokerage capacity. You don't have the same duty as another seller who only has a duty to disclose latent material defects that cannot be discovered by the buyer within reasonable diligence. So the two are just completely different. They operate completely differently. They have completely different obligations. Anything in Form 2T is a legal obligation on the part of the parties to perform the contract pursuant to its terms, or else they may be in breach, or in the case of the two conditions, it's a condition that maybe is not satisfied, and the buyer can have the option to terminate and exercise their rights for failure of the seller to meet condition. In any event, I don't really see a conflict between the two. One is controlled by the committees, as I explained. The residential property disclosure is something that's mandated by the General Assembly, and one of the things the General Assembly tells the commission to do is write this form, which they do, and they're about to do a big change on that. So if you haven't gone and looked at the big changes on that and made some comments, you might want to do that. Next question is impervious surface. Can you expand on that? Yeah. For those of you who don't know, I was the mayor of Clemens for 4 years. And one of the things that we did when I was there, we were having big stormwater problems and not enough money to fix them. And it was in part because people were going out and, putting tons of new impervious surface on the property. And we weren't going out and making sure that we knew about it and assessing the property with respect to stormwater fees. Well, turns out there's technology out there to do that, to go out and make those assessments and find those places. And it was really interesting because some people were finding out, certain neighborhoods, the impervious surface for the entire neighborhood was already maxed out. And so it was a really interesting process to go through on the government side. In any event, impervious surface is stormwater fees. And so what that means is that, a property, if it's raw land, water just goes right into the ground, right? But when you have impervious surface like a roof or a concrete driveway or whatever, those things, the water just runs right off and water cannot get through. It is impervious. So that's what impervious means. And stormwater fees are based on that. So that's what that has to do. If it's not in compliance with that, then that would be something that would be included. Next question, what happens if the work was done 10 years ago, city, county, no records? How do you know if it was permitted or not? Yeah, I mean, that's a difficult issue. I think all you can do is do the best that you can on it. Although I will say sometimes there's other ways to figure it out. For example, today, the permitting issue came up on a hotline call, but in fact, the permitting issue in question should have been covered by the CO. And so even though it was alleged to be an old permitting issue, once the CO is granted, that is satisfying any and all remaining permits. So it was sometimes with things like that, see if there's other ways to get around it. Otherwise, I tend to agree with you that it's pretty frustrating to try and verify permitting for especially things that were done a long time ago. And in any event, it would be on the buyer to somehow show that, there's a permitting violation that's material that wasn't disclosed, that would somehow entitle them to use the condition in paragraph 8H. Is a seller only liable for their time on the property or all owners? It would include, let's say an owner of the property, encloses a porch, same thing as with my previous example. Then he sells the property to someone else who sells the property. Yeah, that's still going to count, even though it was the previous owner. That's still going to be caught under this paragraph. Don't shoot the messenger. I'm just saying, the seller's in the best position to know whether there's that kind of a violation or not. It was just the feeling of the committees that the obligation should be on the seller, although it's not going to be perfect, especially with things like that were done by previous owners. Again, on 8H, when seller is selling inherited property, you're probably going to want to think about striking this, but that's one of the things I want to address next forum cycle is inherited property. I'm not sure this is a good fit for that. Let's see, answered those. Question is, can a seller working with a realtor elect not to use Form 2T? The answer is yes. It doesn't have to be even attorney provided. No. If you got a crazy client who wants to write their own real property contract, that they can do that. I'm not sure I'd recommend it, and you might not want that person as a client, but as far as whether it's legal or not, it is. All you need to satisfy the statute of frauds is the description of the property, the price, and signed by the party who's meant to be charged. Let's see. The question is, why is the word terminate being used when there's no contractual right for the party to do so? Because that's what the party's doing. A seller can terminate the contract, and then they have virtually no right to do so. I mean, there's very few situations where a seller's right to terminate, but they do it with pretty good frequency. The buyer's option in that scenario is to go sue the seller for specific performance, which they're entitled to do also. I mean, just because there's not a right to do something doesn't mean that somebody's not going to do it. Sometimes people, believe they have rights they may not have. Sometimes they just want to exercise, their freedom to do something, even if they don't necessarily have a contractual right to do it. So don't infer the word right with respect to termination. Termination is just the party saying what they want to do, and they may or may not have a right to do it. And that's why they're advised to seek legal counsel for the new check boxes that were added. If you're terminating under 8H, 350 will work, just fine. I don't think there's too much more I need to say on that. That's a repeat. All right. I think the rest of these I've pretty much covered already. We are up against the time in any event. I want to thank you all for tuning in. Another reminder, if I didn't get to your question today, or if you were unsatisfied with my answer, feel free to call the legal hotline. We'll have more time to cover it there, and we'll be happy to do so. Again, just understand we don't write the forms either. So it's our job to help educate people and do the best job that we can. But thank you for tuning in to this Mobile Monday. Hopefully you found it helpful. And if you have any further questions, feel free to reach out to us. All right. Thanks so much.